All right, good afternoon, everyone. My name is Amber Forrest. I'm the Executive Assistant for Connecticut Paid Leave, and with me I have our General Counsel, Michael Caesar. We are going to go over the webinar here, just a few housekeeping tips. Please utilize the QA. It's a feature available at the bottom of your screen where you can submit your questions. We'll be saving some time at the end to answer those. And everyone will receive a copy of the slides and a link to the recording. So I'm going to go ahead and share my screen and we will get started. All right, today we will be discussing Connecticut paid leave coverage for employees of non-public elementary and secondary schools. We also have webinars for administrators, payroll, and HR, but this particular webinar is focused on workers. Note that if you work for a private school, that this is authorized by SBD to provide special education programs. You work for a PSO. 10-76D, duties and powers of boards of education to provide special education programs and services. And section 10-158A, cooperative arrangements among towns, school building projects, and student transportation. So this is any two or more boards of education may in writing agree to establish cooperative arrangements to provide school accommodation services, programs, or activities, special education services, healthcare services, alternative education as defined in section 10-74J, or administrative and central office duties to enable such boards to carry out duties specified in the general statutes. The primary difference between public school operators and non-public elementary schools and secondary schools in this context is the likelihood of the school requiring any of its staff to have certification through SDE. On today's agenda, we will review a brief overview of the CT Paid Leave Program, effects of Public Act 25-174 on schools, CT Paid Leave and CT FMLA basics, responsibilities under Connecticut Paid Leave and Connecticut FMLA, and then we'll save some time for questions at the end. To get us started, I'll provide a quick overview of the CT Paid Leave program. The CT Paid Leave Act was signed into law in 2019 and creates a source of income replacement benefits for eligible workers who need to take time away from their jobs for qualifying health or family reasons. Here's a brief summary of how CT Paid Leave works. CT Paid Leave is entirely employee funded. It's covered employers deduct 1/2 of 1% from their workers' paychecks, which are called contributions. Employers then remit these contributions quarterly to the Connecticut Paid Leave Authority. Contributions are then pooled into the Paid Leave Trust Fund, and when a worker needs to take time away from work for a qualifying reason, they'll apply to Connecticut Paid Leave Authority for income replacement benefits. The employee will also talk to their employer about job protection under the Family and Medical Leave Act, or FMLA, as most of us know it. From January 2022 to date, Connecticut Paid Leave has provided over $1 billion in benefits to nearly 150,000 workers across the state of Connecticut. We're seeing claims come from every city and town, as you can see on our map here, that we update regularly. Areas in red, pink, purplish have a higher usage than claims in lighter blues. As I mentioned earlier, when a worker needs time off from work, they will apply to the Connecticut Paid Leave Authority for income replacement benefits and speak to their employer about job protection, or FMLA. That's because CT Paid Leave and FMLA are two laws that work together, but are not the same. FMLA provides job-protected leave for qualifying health and family reasons. There is a federal and a Connecticut FMLA, both implemented in the early 1990s. FMLA is administered by employers and regulated by either the federal or state departments of labor. Since we're short on time today, we won't go into too much detail on federal versus state FMLA. However, we've included slides with more information as an appendix included in this deck, which we will make sure to provide to everyone after today's webinar. The key to remember is that FMLA provides your job protection, not income replacement. That's where we come in. CT paid leave provides income replacement for the same qualifying health or family reasons as FMLA and is administered by the Connecticut Paid Leave Authority. And we are a quasi-public state agency, which was created in 2019. Just a reminder, Connecticut paid leave and paid sick days are not the same. During the 2024 legislative session, lawmakers passed Public Act 24-8 to amend Connecticut's existing paid sick day law to cover more workers. The law was amended in 2025 to allow boards of education and municipal employers to require that certain employees use their accrued paid sick leave at the increment set in their collective bargaining agreements. The key difference is paid sick days are funded by employers and are used to recover from or care for a loved one with any illness, injury, or health condition. Think routine colds, flu. CT paid leave is employee funded and is used to recover from or care for a loved one with a serious health condition, thinking of recovery from surgery or cancer treatment. So, relevant elements of our Public Act 25-174, which establishes definition of public school operator, mandates that the employees of public school operators and non-public elementary and secondary schools who are not required to be certified are covered by CT paid leave and CT FMLA. Allows the CT Paid Leave Authority discretion to account for alternate pay calendars when determining eligibility and benefit calculations, and establishes a separate eligibility requirement for school employees under Connecticut FMLA. It's important to emphasize this law focuses whether the position is established as requiring the person hired to fill the position to be certified. It is not dependent on whether any particular individual happens to be certified. We anticipate that for most non-public schools, their entire staff will be covered. FMLA covered employers are employers who have, for federal, employers who have 50 or more employees within a 75-mile radius. This is government entities of any size, including federal, state, towns, schools, railroads, and governments of other states. Covered under Connecticut FMLA is almost all employers who have one or more people working in Connecticut, and the state of Connecticut as to all state employees. So who is not covered under Connecticut FMLA? That's pretty much all the folks that are FMLA is covering. There's the federal government, municipalities, public school operators, except for employees whose positions do not require certification under Chapter 166, non-public elementary or secondary schools, except for employees whose positions do not require certification under Chapter 166, and railroads, governments of other states, and other sovereign nations. So, proposed rule for determining quarterly wages. Let's see, all written comments. So you can submit comments regarding the revised consolidated policies to michael.caesar@ct.gov. All comments regarding the revisions must be submitted. I think this is a little old, Michael. Am I right here?
Yes,
I
sorry.
think I'm reading this, I'm going, we actually just covered this. So we do have some new guidelines on the rules for determining quarterly wages. We'll make sure to update this. We just did this. But if a school employee who is not required to be certified is given the option to select among multiple payment schedules, for example, over 10 months, over 12 months, or over 10 months with a balloon, then the quarterly wages will be determined by dividing the annual wages by 4. Michael, do you want to add anything to this that might help make this a little more understandable since we just tied this up?
Yeah, absolutely. So
Thank you.
the way the Connecticut Paid Leave Program works for all employees is that we basically take the two highest earning quarters out of 4 of the past 5 quarters as of the start date of their leave. Because school employees are a little bit unique and sometimes they're given different options on how they're being paid, particularly when they don't have to work during the summer, where some employees can choose to get paid for the entire year and get the same paycheck every 2 weeks or a week. But some employees may choose to just get paid over the 10 months of the school year. And then I know some options are available where they can get paid over the 10 months, but then also get like a giant check at the end of the school year that covers them for the entire summer. Because those are options that are available in schools, we wanted to make sure that those employees didn't have different outcomes when it came to the paid leave benefit. Because at the end of the day, they're receiving the same amount over the course of the year, they're paying the same amount in contributions, but because their wages are a little bit call it like lumpy. They get a little bit more potentially at different times of the year. We didn't want different outcomes on the paid leave program. So basically, when that is an option available to employees, we'll average their income out across the 4 quarters so that there's not sort of differences for those employees who are otherwise earning the same amount and working the same jobs.
Thank you. All right. And for FMLA eligibility changes due to this public act, for federal, the worker has been employed for their employer for at least 12 months. They've worked for at least 1,250 hours in the 12 months immediately preceding the leave, and they work for a covered employer with at least 50 employees within a 75-mile radius. For Connecticut FMLA, this is for most employees. They have been employed by their employer for at least 3 months immediately preceding the leave. And for employees of schools who are not required to be certified, they have been employed for at least 3 months during the previous 12-month period by such public school operator or non-public elementary or secondary school. So we're going to go over some of the basics of the Connecticut paid leave program now. There are qualifying reasons for leave. So the number one would be medical leave, and this is treatment for one's own serious health condition. This actually does cover serving as an organ or bone marrow donor and pregnancy. Nearly half of our claims are for one's own serious health condition. There's also bonding leave, and this is to bond with a newborn or newly placed child, or for the time that you need to process your adoption or foster care placement. So this can be used by both parents. It can be used anytime during the 12 months after the birth or placement, and it applies to birth, adoption, or foster care. And then caregiver leave. This is to provide physical or psychological care or comfort to a family member experiencing their own serious health condition. We do have a few other, they're not as commonly used, but they are available. There's military caregiver leave to care for your family member in the military who has experienced a serious injury or illness that occurred in the line of active duty in the armed forces. Qualifying exigency leave to engage in certain activities arising from the fact that a spouse, child, or parent is on active duty or has been notified of an impending call or order to active duty in the armed forces. And Family Violence Leave Act. This is job protected time off that can be taken by a worker who is a victim of family violence or sexual assault to seek medical or psychological care or counseling for physical or psychological injury or disability, obtain services from a victim services organization, relocate due to such family violence or assault, or participate in any civil or criminal proceedings. And this is up to 12 days in a calendar year. Just a quick note, as of October 1st, 2024, the Family Violence Leave Act also includes victims of sexual assault. So it's important to know that CT paid leave provides benefits for a serious health condition. And that's one of the things that breaks it up differently from paid sick days, where the paid sick days is if you have a cold or flu or COVID or something to that effect. Whereas a serious health condition requires both incapacity and treatment by a healthcare provider. So a couple examples would be a chronic condition for which you see a healthcare provider at least 2 times a year, or a long-term condition for which treatment is no longer effective and the patient is still under medical supervision. This could be a couple examples: Alzheimer's or terminal cancer, or even incapacitation during pregnancy. So who is a family member under Connecticut FMLA and Connecticut paid leave? The primary difference between caregiver leave under federal FMLA versus the Connecticut law is the definition of a family member. So under federal FMLA, an employee can take leave to care for a parent, spouse, or child who is under 18 or over 18 and has a qualifying disability. Under the Connecticut FMLA, an employee can take leave and receive benefits for a parent, spouse, son or daughter of any age, sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity. So what does related by affinity mean? It's pretty much any person with whom you have a familial-like bond that's very significant, like a family member. It benefits, regardless of biological or legal relationship. So this is obviously situation specific and depends on the circumstances. But a couple examples would be like an aunt or uncle who relies on the worker for unpaid care and has maintained a relationship with the worker as typically seen between parents and their children, or an unmarried significant other of the employee with whom the worker maintains a familial spouse-like relationship, regardless of their lack of legal relationship to each other. So there are a couple different types of leave that you'll want to consider when you are thinking about taking time off. There's block leave, which means the employee isn't working at all for a continuous period of time for a single qualifying reason. So basically, it's like you're going to go out on leave, say you're having surgery, and you know that your last day is going to be, a specific date, and you will be out for at least, say, 4 weeks. Um, a reduced schedule would be you're working some of the time, but not much as usual. So normally, say you work 9 to 5, Monday through Friday, but you're going to need to leave at 2 every day for physical therapy. That would be the type of a reduced schedule. It's usually set, you kind of agree on it and with your employer, and you just kind of say, okay, this is the reduced schedule that I'm looking at. And then there's intermittent. Intermittent has a little more flexibility. It's really the employee is absent from work sporadically for relatively small amounts of time. An example of this would be, you suffer from migraines and you need to take time off when one occurs. So, maybe once a month or a few times a year, or maybe it's, more frequent, you wake up in the morning and you have that migraine and that's that time that you need. You never know when it's going to come. It just kind of hits. So the duration of time for benefits is up to 12 weeks in a 12-month period for most leave reasons. There's an additional 2 weeks that may be available for incapacitation during pregnancy, which would include prenatal appointments. Leave under Connecticut's family violence leave law is capped at 12 unpaid days in a calendar year. So who is eligible for benefits under Connecticut paid leave? So the worker must earn at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. So this is what Michael was just talking about. And this is from one or more covered employers in Connecticut. So the worker must be either an enrolled sole proprietor or self-employed individual, currently employed by a covered employer, or have been employed by a covered employer in the 12 weeks immediately preceding the claim for benefits. And Connecticut paid leave makes that eligibility determination, not your employer. So how do you apply? The easiest way, we always say, you can go to our website. It's ctpaidleave.org. We do also accept applications by phone. Once you begin your application and specify your leave reason, you'll receive a notice explaining the documentation that we require for you to complete in order to complete your claim. So usually if you do this online, you'll get an email. It will say, you have a message in your portal. You'll be able to log into your portal and all of the forms that you need to complete will be in there. This usually consists of like an employment verification form for your employer and a med cert, which you would take to your healthcare provider. So here's a quick timeline of case creation to decision. You're going to start your application. You're going to submit your required documentation. This also includes an identity verification. So this could be your state license or passport. Then there's the employment verification form we were talking about, and then documents supporting the leave reason. Your claim administrator will review your documentation, and then a claim decision will be made. If it's approved, benefits will then be issued. So when should you file your claim? The time frame to apply for Connecticut paid leave is about 30 days before or up to 45 days after you need to start receiving benefits. If you apply after 45 days, we're going to ask you like why you waited so long to file. There are a couple of options. I think there might be another where you can just fill it in like I didn't know, or I wasn't sure if it would be approved or something. Maybe you had a hard time getting your med cert back from your doctor, something to that effect. A good cause can include if a worker was hospitalized or impacted by natural disaster or physically or mentally impaired related to their leave request or provided misinformation of CT paid leave requirements by their employer, healthcare provider, the CT paid leave program, or any of its agents. So, what to do if your claim is denied? The fastest way to address a denial is to file a request for reconsideration with AFLAC. If the claim was denied due to missing or incomplete documentation, that's usually fairly the easiest. You would need to be sure to submit those completed documents along with your reconsideration form. If the reconsideration is denied or if the worker does not want to submit a request for reconsideration, you can file an appeal with the Connecticut Department of Labor, but we highly recommend that you do issue a request for reconsideration first before going directly to Department of Labor. So, top 5 things to remember. Applying for CT paid leave is not the same as applying for FMLA or other job protected leave. So claimants should apply to their employer for your FMLA. So your FMLA is your job protection piece, as a reminder. CT paid leave. So just kind of that keyword paid leave is your income replacement benefit. There is a due date by which your required documentation must be submitted, and that can be found in your notice of application, which you'll receive after you've initiated the application. That's that email that I told you that you'll receive, or a letter that you'll receive that states when you need to have your documentation in by. An application is not complete until all of the documents are submitted. So our case managers are not going to begin reviewing your claim until you've gotten everything uploaded, even your identity verification. This also includes selecting the format with which you would like to receive your payment. So some folks are like, they forget that that's a step. Like, we need to pay you. So whether that's direct deposit, I believe we still provide an option where you can get a preloaded debit card that we mail to you, but you do have to select an option for payment also. If you have trouble obtaining your required documents, you can request an extension. You just need to call us or message us. And this would be done through your paid leave AFLAC portal. 4, notified us of any changes as soon as possible. If you're going to return to work earlier than anticipated, or if you need more time away from work, or if you're receiving any other payments from your employer. And benefits are only paid for dates that you would otherwise have been scheduled to work. So basically, if you weren't scheduled to work on a particular day, you will not receive a benefit payment for that day. So next we're going to move on to responsibilities under Connecticut paid leave and FMLA. So the worker, you're contributing your 1/2 of 1% up to the Social Security contribution limit. Your employer is registering as an employer. They're deducting that 1/2 of 1% that you're contributing, and they're remitting that contribution to the Connecticut Paid Leave Trust Fund with the required backup, and that's usually quarterly. And then here at CT Paid Leave, we receive and reconcile contributions, process over and under payments, and impose any penalties for non-compliance. Regarding claims, the worker's responsibility. So your responsibility would be to submit your application in a timely fashion. Again, you can do that online, or you can do that by calling AFLAC. Provide your supporting documentation. Update your account with absence info and information about any other sources of income that you may be getting. And then notify your employer about the Connecticut paid leave claim. It's your employer's responsibility to complete and submit the employment verification form. Notify you, their workers, about its PTO policies, including any short-term disability policies that might apply. And of course, refrain from discriminating and retaliating against the worker for filing a Connecticut paid leave claim. Here at Connecticut Paid Leave, we work with AFLAC to determine your eligibility, review your supporting documents, and approve and deny claims as appropriate. We also calculate and pay benefits, monitor ongoing claims, investigate any potential fraud, and impose penalties as appropriate. And the Connecticut Department of Labor hears to appeals relating to the denial of claims and to penalties. While workers are primarily responsible for submitting their application and providing the appropriate supporting documentation, we will have a school-specific employment verification form, which will ask the employee if the employee is in a position that requires a certification, and if the employee is given the option of choosing from among the several different payment schedules. So also on the form, you'll be asked about the holidays, shutdowns, and school breaks. If the particular employee would not be scheduled to work during a school break under typical circumstances, then you will not get any Connecticut paid leave, as we just went over. On the other hand, if the only reason you aren't working is because of the need for leave, you would be able to get benefits during that time. So just to note, this is also the way that FMLA operates. If the worker is not scheduled to work, then the employer cannot deduct the time against their FMLA allotment. So when your employee files a claim, or when an employee files a claim, they'll give you this form to complete and you return that to AFLAC. Regarding FMLA, the worker needs to notify the employer about the need to take time away from work, hopefully in a timely fashion if possible. Submit your FMLA application. Provide your employer with any supporting documentation and comply with your employer's attendance and call-in policies. For the employer, they have to establish that leave policy, including rules about PTO usage, post their FMLA posters, process leave requests, monitor the leave usage, manage your return to work, and of course, refrain from discriminating and retaliating against the worker for filing for FMLA. For the Connecticut Department of Labor, they promulgate regulations regarding Connecticut FMLA, provide guidance to workers and employers about the program, and investigate complaints regarding denial of Connecticut FMLA claims and discrimination and retaliation. And federal basically does the same exact thing on the federal level. So this next piece is just kind of a quick walkthrough of like how the job protected leave process works. So worker notifies the employer that they need time off from work. You don't need to use the term FMLA. It should basically be implied. 30 days in advance if the need for leave is foreseeable, or as soon as practical if need for leave is not foreseeable. And again, applying for CT paid leave benefits is not the same as applying for FMLA. I know I've said it like 10 times, but we really just want to drill that into folks that we are actually two completely different programs. The employer is going to determine if the worker is eligible for Connecticut and or federal FMLA, and then notify the worker if they need to provide any additional documentation. Usually there's like a med cert that they'll need you to do, which is very similar to what we ask for. The employer has 5 business days to notify you of your eligibility and provide notice of rights and responsibilities, but this is not the leave approval. The next piece is the worker's going to provide the required documentation to the employer to support the leave reason. So generally you have about 15 calendar days to hand in your documents. If you're having trouble getting them, just ask them for more, your employer for more time. Your employer is going to review those documents and notify if the leave is approved under Connecticut FMLA or federal FMLA. Sometimes it's both. Employer has about 5 business days once they've received all that documentation to notify you of their decision. And they must notify you if you need to use PTO and when and how to call in. Generally, it says if a fitness for duty is required. I actually don't know of any businesses that don't require it. So we're just going to say they're probably going to ask you for a fitness for duty, which is also known as a return to work now. And then the worker is going to report to the employer when you actually take the FMLA leave. If you're calling out, say you're doing one of the intermittent things, you'd want to say this is my FMLA leave. If it's a block, obviously you're going to have a last day worked and then a date that you're expected to return back, and your employer is going to track your FMLA usage against your balance. When it's time to go back to work, your employer is going to return you to the same job you had before you went on leave. You have the right to return to that same job with the same terms and conditions. If you were out for your own serious health condition and you have some medical restrictions, the employer can consider whether there are any reasonable accommodations they can put into place to help you perform your essential functions. So questions. Obviously, any questions about Connecticut paid leave, you can reach out to us. You can go to ctpaidleave.org. We do have a contact us where you can reach out to us that way. I know a lot of you already have my email too, so you can always email me or Jessica or Michael. Questions about already filed Connecticut paid leave claims, you can log into your account if you do it online and look at your portal, and you can actually message your case manager right from your paid leave AFLAC portal, or you can call them. For questions about Connecticut FMLA or federal FMLA, we do have a website here that will take you right to their page that discusses those things. There is a phone number and an email for the Connecticut FMLA if you wanted to reach out to them for questions. So I believe that concludes our presentation.